four corners of the statute. So ways to do it. But it takes two. You can't force them to do it, so it'd have to be consensual. Other questions? Do you want to take some of those cookies and drinks for them?
Yeah.
Why don't we do it now since it's halfway through?
Take a 5-minute break, and we'll come back. There's some drinks and cookies out there. Make sure you're signed up. If you're not on the list, put your email address on there, legibly, of course.
You know I'm just babbling.
No, this, it's good,
But so long as I keep myself, I can keep myself going through it. The prime facie, I'll leave a few minutes for the evidence stuff. How much time are you going to need?
Not very much, but I was thinking maybe what I could go on, how much you're gonna cover, just kind of what my typical day, like, cause I've never even been into court. I just usually answer questions in the morning, do mediation.
And we
So
can talk about what the...
just, you know, just like a brief.
Why don't you do that?
And then come back
I'll come
to
back to this,
this?
so you guys
Okay.
are, because I don't want to keep her to the very end because the time, it's going to wane.
Oh, you're all on them.
Okay, I'm ready.
Okay. World's smallest cookie.
They give you a fair number of them.
I do.
Good. I got my brother moved already. 4 hours and moved in like 3 floors. They started off as like, help me move a couple boxes, and it's like an entire U-Haul. Yeah. Well, he's not moving. That's the thing. Like for a couple months. But they kind of like knocked me out. I'm sorry.
Oh, yeah, which one? Yeah.
So do you still teach any classes at BU?
Yeah. I've been teaching a housing seminar
Okay.
for like the last 11 years. And I teach this fall semester, so I'm in the middle of doing it now.
Yep. I went to BU,
Oh,
but
really? Oh, when did you graduate?
2009. But I wish I'd taken more classes like that. You know,
And just being lectured at?
yeah, and taking, you know, it's like, oh, immigration or housing, you know, it's like, oh, I'm not doing any of that. But I actually do a lot of pro bono and stuff like this, and I'm like, I wish I'd taken a class back then.
So what do you, which department are you in?
I do environmental.
Okay.
So I literally had no landlord tenant experience whatsoever. And I think it's a great testament that anybody can do it. But
And the thing with environmental, my wife, for many years, was at Hale and Dorr when it was Hale and Dorr.
Yep.
And she initially was doing environmental litigation.
Okay.
And it got to the point that she was actually litigating these cases. It got to the point that it got so expensive that the clients have moved to a different model.
yeah, no, it definitely, some of those, kind of with any,
You need to herd the sheep.
Email from Max about their new EA regulations.
I wrote them back saying that it would make a good topic for our housing seminar, the housing court seminar, education conference. But I can't do it. I can't do it. Yeah, but I can't do it until the final regulations come out. Yeah, they haven't decided on the final regulations. I know. Well,
Maybe a lack of understanding what's really happening out there.
yeah.
'Cause I think the idea was, the heart was in the right place. Oh, housing is better than shelter. Well, yeah, but.
Yeah. Do you want to herd them back in?
Yes,
Yeah,
okay.
Because,
all right.
let's see. Or else it'll be a half hour.
I just can't get enough of the cookies.
Welcome back. We're going to go now to Katie Ward from Mintz Levin, who's going to talk about her firm experience at the housing court and how they handle it. She's sort of the person there who organizes their participation, and also talk a little bit about her personal experience there at housing court and what you can expect when you show up.
Hi, everyone. My name is Katie Ward, and I'm actually in the environmental section at Mintz Levin. I had absolutely no landlord-tenant experience before starting to volunteer for the Lawyer for the Day program, so I think that's a testament. Anyone can do this. And I just wanted to give an overview of our program and then my experience. So our program at Mintz, and it varies between firms, is we go once a month. And we there's a group of us who go, and so we'll send around emails, see when the most people can go, and then schedule a trip, and we just show up. And once a month and go. Other firms, they have whole months where they'll go for the month, and it's every Thursday they'll attend, for that month. So there's different kind of models, but there's always, I think it's important to note that there's always someone like Joanna or someone else with a lot of experience there. So, the first few times that you go, you can, there's someone always there to ask questions. There's someone, the first few times I went, I just shadowed someone and kind of as they answered questions. And truthfully, I've never been into housing court. I've never argued a case. I tend to be there in the morning and will answer questions, and then sometimes if I can stay late enough, I'll go into mediation with the tenants. And so there's lots of options for the program. If you're overwhelmed, okay, maybe I don't want to go, I want to work up into taking a case. There's lots of different things that you can do. And it's just, I just want to emphasize how even just by answering people's questions, what a difference you can make. Even if you're not going to go in and represent them, there's so many people who come in and they don't know their rights. They don't know that in Massachusetts, the laws are, really friendly towards tenants. And, for example, you ask them, this happens so much, they're getting evicted, they just need more time to move out, and they just feel like this is it, like they're evicting me, there's nothing I can do. And you ask them, okay, do you have any bad conditions in your apartment? Well, not really. Well, do you have mice? Yes. Do you have cockroaches? Yes. How are the windows? Well, sometimes they leak in the winter. And it's like, okay, you do have bad conditions in your apartment. There are counterclaims that you can bring that will, that could be more, it could end up that, you don't owe as much, or you owe, the landlord owes you money because the conditions are so bad. So, just learning about the different rights that tenants have, you really can, in just a short amount of time, help them answer questions, even if you're not going to take the case, even if you're not even going to go to mediation. You can help them, you can prepare them, and let them know their rights. And just a few pointers, just always asking for any papers that they have and getting their whole story, because without fail, you think you have it, and then all of a sudden you realize they've been in court 2 other times on the same matter, and you're like, oh, okay. So, really getting, they're not familiar with the system. They don't connect it. They're like, this is a new, so just really trying to get to the bottom of it, and really just asking for any papers that they have, and really trying to figure out, what's going on. This is especially important if you're not taking the case, if you're just answering, even if you're just answering questions, to really, figure out what's going on. And then, let me see if there's anything else. I also just wanted to note that, we tend to start getting there at 8:45 in the morning, and then, kind of staying as late as people can. But we just want to note that we've found in the mornings it's actually kind of less busy because people are going into court sooner. And so it's actually a good time to come is maybe at around 10:30, and then you can stay until 1 or something, and then that way you can take on a case or take on a mediation if you give yourself more time. If you don't have the whole day, you only have a few hours that you can come, that sometimes we're kind of discovering that the morning is not, there's not as many people asking questions. So I think that's all I had to add.
Okay. Any questions before we go on?
Yeah, any questions for me on my program or my experience or anything? And I'll be here after if you want to talk to me.
And at the end, I'll talk a little bit about what VLP can offer you and how to get signed up and everything. But for now, let's go back to the prima facie case for possession.
All right, what I'm going to talk about with the remaining time are 2 things. I'm going to go through the elements of a summary process case and some of the defenses. With the remaining time, I'm going to give you what I call my down and dirty discussion of evidentiary issues that recur in housing cases and how to address them. So, or at least identify them. If you're going to identify them, then you can resolve them. But first, let's start with the prima facie case for possession. Landlord's prima facie case is very direct. You've got to establish that there was a landlord-tenant relationship. I'm the landlord. This is the tenant. Sometimes not so easy. We'll talk about that in a little bit. That this tenancy was terminated by a legally sufficient notice to quit. That requires you of necessity to know what type of tenancy it was. Was it a tenancy at will? Was it a tenancy under a lease? Was it a tenancy under some federally regulated program? What's required by the notice will differ depending on that. So you have to factually identify it. That, in fact, the notice to quit was delivered to the tenant, that the tenant received it. We'll talk about that. And then that the landlord is entitled to recover possession either because the tenant violated some obligation or duty, failure to pay rent, behavior, whatever it is that the landlord is saying, or that the landlord has proved the right to recover possession if it's contractually based or regulatory based tenancy, that the landlord has established that, for example, they need the apartment for a member of their family. And that's the prima facie case. When you look at a case for the first time, take a look at the notice to quit, take a look on the date it was served, figure out how many days it was to terminate the tenancy, take a look at whether the summary process summons and complaint was served after that date. That's something different from whether the notice itself is legally sufficient. Take a look and see if the timeline is correct. Simple issues with the first element, proving that there's a landlord-tenant relationship. There are different types of people who can bring a summary process case. The owner can bring it. The property manager can bring it, because any landlord can recover possession. The issue is whether the plaintiff has a superior right to possession over that asserted by the defendant. Now, obviously, there may be some agency issues that you have to address. If someone is holding themselves out as an agent of the owner, saying it doesn't make it necessarily true. It's something that you could require proof of. Sometimes you're going to find it takes the form of an affidavit, or more importantly, a power of attorney from the owner authorizing someone to work. You have to take a look at the power of attorney. Is it a valid power of attorney? Was it enacted properly? Is it still in effect? You have to make those determinations. But the property manager can bring it either in their own name or in the name of, as an agent of the landlord. One little thing to look for, if it's a property manager who is suing as agent for the owner, there's a case that's cited in the DISC last v. Collection v. Pagan, which talks about under what circumstances a pro se property manager can appear in court rather than being required to be represented by an attorney. I'll leave you to read that. It's usually there's side issues, but sometimes it can be an issue that you can raise. Now, I'm not just going to go far beyond what we can talk to today, but the issues of who can sue is a issue of paramount importance in post-foreclosure eviction cases. Because in a lot of those cases, either the tenant or the former owner is asserting that the person who is bringing this case does not have a superior right of possession, because they're asserting a title to the property that's based upon a invalid foreclosure. So rather than telling you and discussing all the different permutations, if you have a post-foreclosure eviction case, take a close look at it. Who is the owner? What do you believe the owner's going to have to, the plaintiff's going to have to present to prove that they have a right to possession? And consider what defenses you might want to assert. You also have to identify, as I said, what type of tenancy you're dealing with and identify what are the specific terms of that tenancy. If it's a written lease, for example, under all circumstances, you have to give 14 days if it's non-payment of rent. But if it's a cause-based and the lease says you can terminate this written lease upon 7 days' notice, that's going to be sufficient. Whereas if it's a tenancy at will, 14 days is fine for non-payment of rent, But if it's any other reason or no reason, then you have to give a full rental period's notice under statute. You may have a situation where owner serves a notice to quit, commences a summary process case, and while that summary process case is pending, the owner sells the property to a new owner. The old owner no longer has any right of possession because they've sold the property. So effectively, what would have to do is the new owner would have to move to intervene and be substitute as a party plaintiff in the summary process case. Then if it's a claim for non-payment of rent, one of the things that the plaintiff would have to show is that the former owner assigned to the new owner the claim or the rents. Slightly different issue if it's just a no-cause eviction, in which case it would seem that the new owner can simply move to be substituted as a party and can rely on the prior termination, unless the new owner and the tenant engaged in some transaction that would constitute the formation of a new tenancy. In other words, the waiver issue argument again. Then you have to prove that the tenancy was actually terminated by a legally sufficient notice to quit. The notice needs to be clear and unequivocal. I've seen these notices, I hope that you're able to leave sometime before the end of the month. Maybe equivocal. Is it a statement of intent to terminate, or is it an aspirational document that's just supposed to be the beginning of a discussion? That's legal argument, but you have to be looking for it. Check to make sure that the time period is accurate. If it's a lease, make sure that if it calls for 7 days and a non-payment, for other than non-payment, you measure it not from the date set forth on the notice, but on the date that it was delivered to the tenant. Unless, of course, the lease has in it a clause that deals with notice, in which case notice is presumed to be received as of the date it was mailed. Contractually, if it says it, may be sufficient. But you have to look to your document and then do an analysis. There are 500 permutations off of that that I'm not going to discuss, but the important thing is to satisfy yourself that the notice sets forth the correct time period on its face, and that the actual time period is covered, measured from delivery to end of time period. Where do you run into some problems? If the tenancy at will, and it's for other than non-payment of rent, the notice, the statute says 30 days or a full rental period, whichever is greater. There is then case law going back to the 19th century, early 20th century, and sometimes mid-20th century, that says that a termination of a tenancy at will must terminate the tenancy on a rent day. Now, rent day has been interpreted to mean either the expiration of the month next after you receive the notice. So if you got the notice on, September 28th, and the notice says this terminates at the month next after the date you receive this, that's presumed to be the expiration of October. Good notice. If it says it terminates on November 1st, good notice, because it expires on a rent day. But if you get your client gets a notice delivered on the 28th of September that says this tenancy of will shall terminate in 30 days, defective. because it's not a full rental period under the statute, because it's 30 days or a full rental period, whichever is greater. And based upon the common law cases, it doesn't terminate the tenancy at the expiration of the rental period or on a rent day. So you need to look at the notice hard. There are trick months. There's one, February. And all you have to do is on January 31st, landlord serves a notice to quit saying terminating the tenancy at the month next after the date you receive this notice. And certainly great as far as at the end of the next rental period, it works. But it's 30 days or the expiration of the next rental period, whichever is greater. So you haven't given 30 days. Unless you're lucky enough to have well, it doesn't even work then if it's a leap year, because it'd still be 21, 29 days. It doesn't work. So if you have a February date, if you're a landlord, you serve it 2 weeks earlier or a week earlier to make sure that you get the full rental period. But I've had cases that have been bounced because of the February conundrum. So look at it. The notice itself must state the reason if it's cause. If it's non-payment, you have to say non-payment. You don't necessarily have to say how much, but you have to say for non-payment of rent. Typically, notices to quit do include the months that rent is due, and invariably there's a dispute as to whether that's correct or not. But for purposes of a defense, or for the landlord's case, the landlord has to show, if they served you a notice to quit for non-payment of rent, they have to establish that on the date they served you the notice to quit, the tenant was in arrears. The tenant was, you get a notice to quit on September 28th, claiming no rent for September. But the tenant paid the rent on September 21st. There's no non-payment claim because the tenant paid. The other thing you should look at with a notice to quit for a tenancy at will for non-payment of rent, the tenant has 10 days to cure, measured from the date they got the notice to quit, if they had not gotten another notice with similar notice within the previous 12 months. And then if the tenant pays, the landlord within the 10 months, and then doesn't pay the next month rent, but the landlord brought an eviction action based upon the notice to quit for the month of September, that case gets bounced. It's true, the tenant hasn't paid rent for the next month for October, but this case was based upon a termination of a tenancy for failure to pay rent in September. If the tenant cured it before they were in arrears for the next month, so if the notice comes on the 21st of September and the tenant pays the rent on the 28th of September and then doesn't pay October, the landlord cannot proceed with the September, based upon the September notice, because the tenant had cured the default and reinstated the tenancy by that act. So look at the dates. A tenancy at will termination of a tenancy at will notice can include an offer of a new tenancy at a higher rent, beginning the first day of the month next after. Even though there's some ambiguity in it, the law says that you can terminate and offer new tenancy at the same time and the same notice. The problem in court comes in is when the tenant has paid the old rent but refuses to pay the offered increased rent. And in that situation, that notice is good notice to terminate because the tenant never accepted the terms of the new tenancy by paying the higher rent. But it's always an issue. If it comes up, just look for it. All tenants must be named in the notice, or at least all tenants have to receive their own separate notice of termination. It can be done either way, but each tenant has to be served with the notice. So if it's a tenancy at will and there are 3 co-tenants, all 3 have to be receive notices. If the landlord serves 2, then you can't proceed in summary process. And the reason is simple. Summary process is a cause of action where the landlord is seeking to recover possession of an apartment, real property. You can't do it if you just proceed against 1 or 2 of the co-tenants. So you can't cherry pick. The landlord has to name all. If it's a lease, same thing. The landlord has to name all of the tenants who are on the lease. But again, depending on what the lease says, it can be 1 notice, but served on each of the tenants. We talked about the statutory cure. Notice to quit under statute has to have language in it, the tenancy at will, that includes the statutory cure language. If the notice to quit does not contain it, it is not fatal to the landlord's case. What the statute does is extend the date on which the tenant can cure up until the date the answer, summary process answer, is due. So if the tenant gets a notice to quit non-payment of rent, doesn't include the cure language, landlord then serves a summary process summons and complaint. The answer is due on the Monday before the Thursday. If the tenant pays cures by that Monday, landlord can't proceed to recover possession. Problems that you should be looking for. Landlord serves multiple notices to quit. Let me give you the best example. Landlord serves a notice to quit in in April, saying that the tenancy at will is going to be terminated at the expiration of May. 2 weeks later, the landlord serves a 14-day notice to quit to the tenant. That includes the statutory cure language. Anybody think that those 2 notices are inconsistent? 1 notice to quit, terminating tenancy at will without cause, expires at the end of May. 2nd notice to quit, served at the beginning of May, terminating the tenancy at within 14 days, including the statutory cure language. Is there a problem? Like my seminar at BU. The answer is possibly, very possibly. Let me explain what you should be looking for. Termination has to be clear and unequivocal. That's what we know. It's unequivocal that there was a notice saying that your tenancy is going to terminate at the expiration of May. But the 2nd notice, the one for non-payment of rent, says if you pay within 10 days, then your tenancy is reinstated. If the tenancy is reinstated, the ambiguity is, does that mean that I'm still subject to the earlier notice, or by this act, have I now become a tenant again, requiring the landlord to start over? There is case law, decisional law, at least at the trial court level, that those notices are inconsistent, and the ambiguity will defeat the landlord's claim for possession. So be looking for it. The other problem that you have to think about is a notice that has multiple reasons for termination. You didn't pay rent, you throw garbage out the window, and your sister is living there without my permission. All in the same notice. If it's a 14-day notice to quit, the landlord can proceed only on 1 ground: non-payment of rent, because there's not valid notice sufficient to raise the other issues. If it's all subsumed within a 30-day notice, then the landlord technically can proceed, but you have the same potential problem. What if the notice doesn't include the statutory language for non-payment of rent, and the tenant does pay all the rent due by the date the answer is due? Has the tenancy been reinstated, notwithstanding that the landlord has these other claims? The law is that an ambiguity in a document drafted by the landlord is going to be interpreted strictly against the landlord. So you have a potential argument. There is a provision, Chapter 186, Section 13, that said that tenancies at wills are not terminated by operation of law by the landlord's conveyance of property. Up until recently, that still means if I'm the owner and I sell the property to Joanna, and you're my tenant, you become Joanna's tenant, tenancy at will. If it's a lease, the lease will govern, and the lease will follow to Joanna unless there's some, it's 7 years or more and it's not recorded, and then there's certain priorities. The law has changed dramatically since the foreclosure crisis has hit with respect to tenancies post-foreclosure. I'm not going to spend a lot of time with it, but the law now is that, as a matter of state law, tenancies in existence at the time of foreclosure survive foreclosure. Historically, foreclosure terminated tenancies by operation of law. That was the old common law. Statute changed that. 183A. Chapter 186, Section 13A. Chapter 186A now provides significant more protections for tenants in post-foreclosure properties, at least with respect to those who are holding title as the first owner out from foreclosure. So read the statute if you have a tenant who is in a property that's just been subject to foreclosure. There's also federal statute, which affords rights to bona fide tenants. Read the statute as to identify what a bona fide tenant is. But the federal statute has been interpreted to says that the first owner out of foreclosure has to provide the tenant with at least 90 days notice of termination. The federal statute does not draw a distinction between cause or no cause evictions. So even if it's a termination for non-payment of rent, which is a matter of state law, requires only 14 days, at least arguably as a matter of federal law, entitles the tenant to at least 90 days notice. So again, if you get a foreclosure case, take a look at the statutes, take a look at your documents. And that's what the next slide just cites you to the statute and to the state post-foreclosure. You may get a case that involves subsidized housing. Two types: public housing, BHA, Boston Housing Authority. The other is Section 8. And it's either going to be project-based Section 8 or voucher-based Section 8, where voucher being where the tenant has a individual voucher, goes to a private landlord, enters into a tenancy regulated by HUD through its agent. Usually it's BHA or Metropolitan Boston Housing Partnership, MBHP. Those are tenancies by contract, by lease, but there are Section 8 lease addendums which incorporate the provisions of the HUD Section 8 regulations. And if you get a subsidized tenancy, case, you need to read and familiarize yourself with both the lease and lease addendum and the HUD regulations. Tenants have substantially more rights in subsidized housing than they do in private housing. One, the notice that a landlord must send requires more information, and there's specific language in the HUD regulations that need to be included in those notices. So look for it. Two, the regulations require that the notice to quit be delivered to the HUD, the Section 8 leasing subsidy agent, BHA or MBHP, at the same time that it's delivered to the tenant, or near the same time. So if the tenant sends a notice to, a landlord sends a notice to quit to the tenant, terminating a tenancy, Section 8 tenancy, and a week later sends a copy of it to the subsidy agent, good enough. But if they wait until after the summary process action is commenced, it's not at or near this time. So there's going to be a defect that would entitle you to ask the judge to dismiss the case for the owner's failure to follow HUD regulations for the termination of a tenancy. And you'll get this case dismissed even if the tenant otherwise didn't have a leg to stand on. The landlord has to assert good cause to evict. Now, good cause could be fault on the part of the tenant, or something called other good cause within the four corners of the HUD regulations, which would include a personal or business reason identified by the landlord. But the landlord has to identify with some specificity in the notice what the reason for termination is. And you may find that you don't think that the information in the notice or the reason in the notice was specific enough. That would give you at least an argument to raise at trial. Judge may not agree with you, but again, it's something that you can present. But be ready to tell the judge why that didn't give your client enough information. What was the harm to your client? Didn't your client really know what this was about? Be prepared to tell the judge why that answer should be no, and why fairness would dictate, consistent with HUD policy, that more be included in it. Here's a typical notice to quit. Ironically, it's Bruce and Springsteen. I just got an email from Miss Allison the other day in which she made some reference to Bruce Springsteen. Typical notice to quit. Take a look at it. Simple notice to quit alleging chronic late payment of rent. Is there a problem with that notice? There's going to be a free cookie for the person who gets the answer. Yes?
Should there be the statutory language of
It's chronic late payment rather than, and as well as non-payment. So the answer is they don't have to put it in, but they may have extended the time which the tenant can cure for non-payment. What else? This is what we call close reading. Take a look at the address at the top. Where does Richard Tenant live?
I don't know if it's apartment 3 or if it's apartment 1.
You don't. But regardless, the landlord is giving notice that they were terminating and wanted possession back from apartment 1. So one of two things happen here. Either you have the wrong address for termination, or you have an argument that your client didn't get the notice to quit, if in fact your client didn't get the notice to quit. If your client actually got the notice to quit, and the body of the language says apartment 1 and that's the correct apartment, then you may not have a problem. But if it's flipped, if your client does live in apartment 3 and the landlord terminated your right to occupy apartment 1, a legally deficient notice of termination. And I will not correct that error at the time of trial. That's deficient on its face. But that's just by way of example of, yes?
I have a question. So when we're talking about deficiencies and notices, and so it gets kicked out for the landlord, are they just going to then reserve another notice? But that, I guess the advantage for a tenant is that it can get the extra 30 days then.
There can be there are a lot of potential reasons that may benefit the tenant. One, it may buy the tenants more time if that's what they're looking for. Two, if they have more added time to cure. Let's assume this was a problem where they owed rent. Between the time that this is dismissed and the landlord sends a new notice, you may be able to get the tenant into compliance with the terms of the tenancy. If it's a cause-based eviction for behavior, it gives you more time to try to connect your client to social services that may be able to provide you with a potential reasonable accommodation defense, if that's where you want to go. So but you should talk to your client before you simply say, yes, I'm going to push to dismiss. Your client may want to get it resolved, but you have to discuss it with your client. The notice to quit was actually received. The tenant's going to say, I never got the notice to quit. The landlord, forget about constables and sheriffs, the landlord says, I gave it to the tenant and delivered it in hand to the tenant. If the landlord testifies to that, if the tenant testifies I didn't get it, simple question of credibility for the judge. And I have to decide it. But let's assume it's served by a sheriff or constable. The sheriff or constable says, I gave it to the tenant in hand. Tenant says I never got it. By statute, a return of service by a sheriff or constable is prima facie evidence of the service as set forth in the return. So I can, it's prima facie, but it's not irrebuttable. So I can listen to the tenant. I have to decide whether I credit the tenant. If I don't credit the tenant, the return of service is sufficient. Where it gets a little bit dicey is where the landlord, the constable or sheriff has served the notice to quit last and usual at the tenant's apartment and then sent a copy of it by first-class mail. Return receipt. That's what the typical return says. The tenant testifies, I never received it. The judge could simply find that the tenant did not testify credibly and the return of service is adequate. But if the judge believes the tenant, at least has no reason to disbelieve the tenant, a landlord might have to bring in the sheriff or the constable to testify what it is that the sheriff or constable did. For example, the landlord gave me access to the front door to the building, and I slipped the note under the door, physically under the door of the tenant. And I then went back and mailed it, and this is where I mailed it. I put a stamp on it, I took it to the post office, and it has not been returned to me. So he has the right to, he gets the evidentiary presumption of receipt upon mailing, and you have the constable testifying, and I have to determine whether I believe the constable. So just be aware that if you have a last and usual, you may have a potential defense, and at least force the landlord to put on proof. And you have to prove that the landlord has to prove the tenant didn't leave. Usually it's established, but not always.
Mm-hmm.
The landlord always has the burden of proof on the issues of cause. So if the landlord doesn't put in testimony, just says, I want the tenant to leave, if it's and they've alleged cause, then it's not proved, and you can move for directed finding at the close of the landlord's case. So just be listening to what the landlord is saying. If the landlord is claiming non-payment of rent, if the landlord actually can testify from memory as to what rents were collected, what weren't, but sometimes the landlord has what they call a rent ledger. Take a look at that rent ledger and determine whether it's something that looks like a business record. Now, even if it can't be used as a business record, it may still be able to be used by the landlord for other purposes. For example, refresh recollection, or even potentially past recollection recorded. It's possible, but you might be able to keep it out as a rent ledger. Before I go into evidentiary issues, and I haven't talked about defenses, and well, actually I have a few minutes so I can talk about defenses, but before I go to defenses, any questions? Yes?
I have a question. In that notice, it says that there's an unauthorized person living in the premises. So how do you deal with if there are occupants, you don't know the names of them? Do you name unknown occupants as defendants so that the
I mean, if you were the landlord?
Yes.
No, you name well, they do. I should say that's, but we don't act on alias or John Doe complaints. So if there was Jane Tenant and unknown occupant, I would not enter a default or a judgment against unknown occupant. The issue is going to come up where you serve Jane Doe, and Jane Doe says that John Doe is my co-tenant, and he's been my co-tenant since I moved in, and the landlord knew it, the landlord's accepted rent from John Doe, and the landlord hasn't named John Doe. That gives the tenant a defense. The landlord can take the position that the only person I rented this apartment to is Jane Doe. There's someone else living there, I don't know who that is, or I never accepted that person as a tenant. And then the landlord's position is I'm only obligated to terminate the tenancy of the tenant who I contracted with, and whatever rights that other person has is by and through the named tenant. So if the landlord terminates as to the named tenant, and the named tenant has to vacate, the other occupant has to leave with the tenant.
So there wouldn't be any issue like if the sheriff is looking at the order of possession and only one person's name is on there and they get to the house and there's other people to evict.
There's always a problem. And it depends on the sheriff or constable. Some sheriffs and constables will just say, you're all out. Other sheriffs are going to say, I can't levy, constable, I can't levy on this. Calls the landlord. The landlord's going to have to come running into court, usually seeking an order from me, direct saying that he can levy upon anybody who's in the apartment, but it has to be fixed. But probably 90% of the time, 95% of the time, the sheriff or constables will move out whoever is there. Where I get it is when the sheriff or constable delivers the 48-hour advance notice that I'm coming on Friday to evict. Tenant gets the notice on Tuesday, or whoever's living there gets it on Tuesday. They come running into court on Wednesday to me saying, this person got this notice, but it doesn't name me, and I'm a tenant also. I'll get an order of notice out for get the landlord into my court before the levy date, and I'll hold a hearing to determine whether to issue an injunction, either TRO, temporary restraining order, or preliminary injunction, to flesh out the issue of occupancy. That's more typically how it shows up. Other questions? Yes?
If a piece of property is in the name of an LLC, and the manager of the LLC wants to come in and represent himself, which would be the LLC essentially, as the landlord, does the housing court allow this person to represent himself per se, or would that be?
No, there is case law that says that a corporation has to be represented by a lawyer. So I actually issued an order about maybe 10 years it's been now, where I said as a prophylactic measure, a corporation that commences a summary process action in my court through an agent rather than a lawyer, I will automatically dismiss. Because it's too easy for the corporation simply to have their employee run down to the court, sign the complaint, file it, and then say, well, if anybody calls me on it, or if the tenant shows up, I'll hire the lawyer who's hanging out in court to enter an appearance. I just decided to nip it in the bud, and unless the corporation has a very good reason for not having had a lawyer, I'll just dismiss. Yes?
Same question, but for trust?
There's nothing that says that a trustee cannot represent the trust. If you think about it, the property is owned by the trustee. So I don't require, but it gets a little bit dicey if the interest is being asserted by a beneficiary in a real estate trust. Then it becomes a little bit more difficult. But there is no per se rule against a trustee appearing without representation. Other questions? Okay, let's spend a few minutes on defenses, and I'm only going to talk about two. There are legions of them, and if you take a look at some of the materials that VLP has, they cover them very well. Chapter 239, Section 2A, the retaliation. Retaliation is a defense even if the landlord can prove the grounds for termination. For example, it's non-payment of rent, and the landlord can prove that the tenant hasn't paid 2 months' rent. If the tenant can establish that, notwithstanding the issue of rent, the real reason the landlord terminated my tenancy was because I had complained to the city of Boston about bad conditions, or that I called to complain that there was illegal levels of lead in my apartment. And that's the reason that the landlord evicted me. That can form the basis of a defense to possession. When the landlord can prove the underlying cause, it makes it somewhat easier for the landlord to rebut the presumption of retaliation, if it exists, by showing that the landlord had an independent basis for terminating, and the landlord would have taken that action even if the tenant had not contacted the city or complained about the lead. But so analyze that defense without regard to whether independently the landlord may have a basis for terminating. Might provide a defense. Hard, but it's there, and you should look at it. 8A, Chapter 239, Section 8A. The most basic fact that you should look for in an 8A defense, which is the one that says that the tenant can prevail on the claim for possession because of bad conditions in the apartment. The thing to look for is whether you can show that the landlord either knew or should have known of the defective conditions that have to be of some significance before the tenant was in arrears in the tenant's rent. Now, when you get the cases on Thursday, the typical fact pattern is going to be that the landlord serves the tenant with a notice to quit for non-payment of rent. The next day, the tenant goes to speak to somebody who says, here are some things that you can do. The tenant calls the city inspector. The city inspector comes in and finds 3 pages of conditions, writes them up, and serves the landlord. The issue is going to be whether the landlord knew or how long did those conditions exist, and when was the first time the landlord knew or should have known. So don't shy away from a 8A defense simply because all of the paperwork starts after the notice. That's the typical case. The factual issue is going to be, what did the landlord know and when did the landlord know it on those defenses? The other thing you need to think about for an 8A is what I call the problem of the Pyrrhic 8A defense. The Pyrrhic 8A defense is that you're representing the tenant, you can't establish the elements for the defense, and that there were conditions that constituted a breach of the implied warranty of habitability, and that the court would be willing to abate the rent. But the damages are not so significant that it wipes out the rent arrearage. So the tenant still owes rent. Under 8A, the tenant would have to post that rent, the amount due, with the court within 10 days. It says 7 days, but I had 10 days, 3 days for service. So within 10 days, the tenant would have to post that money with the court. So you spend hours preparing your case, you do a magnificent job of trying the case, because you think you have a lock 8A, which you do, and you get a judgment, at least a decision in your favor, but your tenant doesn't have the money to post the amount due, so your client loses, and judgment enters for the landlord because they haven't complied with the payment order. You need to speak to your client at the beginning of the case to find out what they can do, because that may impact how you go about trying to settle the case. 8A says that the tenant can assert any counterclaims arising from the tenancy in the summary process case. To the extent that it's going to provide a defense, the damages either have to wipe out the rent arrearage, or they have to be damages that are related to conditions to be able to get the 10 days to post the money. So you need to carefully evaluate your claim. There are a lot of other potential defenses that may be available to you. I just encourage you to take a look at the VLP program materials that they provide you. One of the best defenses, by the way, in a cause case is my client didn't do it. Or stated in a more likely fashion, you can't prove that my client did it. It's a civil standard, preponderance of the evidence, but sometimes if you don't have to prove anything, your whole defense may be to keep out the evidence that the plaintiff is trying to present. And that could be that the landlord is trying to present hearsay. The neighbors complained about the tenant. None of the neighbors are there. If the landlord didn't see it, didn't observe it, what the neighbors had to say cannot be offered for the truth of the assertions. It can only be offered for explanation of why the landlord commenced the summary process action. But that's not proof of the violation. So you need to evaluate on a cause case, what is the landlord's proof going to be? And then be prepared with your evidentiary objections to meet it. Let me go through some basic evidentiary pieces, and then if we have any time at the end, I'll take questions or fill in with some other advice. City ordinances and city regulations. Best examples I had here is the rent control ordinance when it was in existence, Boston zoning code. Court cannot take judicial notice of those documents. So you either have to get a stipulation from the other side, or you have to bring in certified copies of those documents. How does it work in the real world? The real world is you get the stipulations in advance, and you'd only give me those pages, because I don't want you to bring in the entire Boston zoning code. Has anybody seen it recently? Mm-hmm. It's something like this. It's like the Oxford English Dictionary. So just get the provisions that you want me to look at by stipulation. But Otherwise, you have to think about the evidentiary foundation for it. In contrast, regulations published in either the CMR at the state level or CFR at the federal level, the court can take judicial notice of those documents. So you can you can just ask me to take judicial notice of a HUD regulation. Good practice is to have the provision that you want me to see printed, ready to give it to me. And just don't rely on the fact that I can just run in onto Westlaw and just pull it out. Give me the page and highlight the provision that you want me to look at. Just good trial practice. Same thing with the Attorney General's regulations, state fire and building codes, because they are state regulations published in the CMR. And the state sanitary code, which is going to see something you're going to be working with too, is published, so I can take judicial notice of it. There are certain documents that by statute I can take with a inspector's certification. A violation notice from the City of Boston building inspector or ISD code inspector, I can take, so long as it's certified by the inspector who did the inspection, usually attesting that the conditions existed and they materially endanger health and safety of the tenant. That is prima facie evidence that the conditions listed in that report existed on the day that the inspector was there. It is not prima facie evidence that they existed on any other day in the past or future. It would allow me as the judge to draw an inference that, depending on what the type of condition it was, that if it existed on that day, it existed earlier. But I'm not obligated to draw that inference. So if you have an ISD inspection report on that your client got 2 weeks before trial, and your client is telling you that those conditions existed for the past year, you have to put in evidence to establish that those conditions existed for whatever period of time you're trying to prove. It could be testimony from your client. It could be photographs that your client has, if you can authenticate when those photographs were taken. It could be testimony of an earlier inspection report that may have existed. If the property was newly purchased, the new owner may have had an inspection done of the property. You can, through discovery, try to get that inspection report and see what the private inspector said and try to use that. But it's only the state inspector's regulations that go in. The report is not proof that the landlord received it or had knowledge of the conditions unless there's a return of service showing that it was served on the landlord, and then at least as of the date of the return of service, it's prima facie evidence that he knew it as of the date of the service. But you'd have to separately put in evidence to prove landlord knowledge of the conditions. Constables, we talked about constables' return of service. Money order receipts, which we deal with all the time. What's a money order? Money order is a simple drawer certificate for a amount of money. The purchaser gives the bank $100. They give the purchaser a money order. Money order has a original top and usually a bottom copy that has through carbon you can copy. Sometimes the name of the drawee is not printed by the selling agent, the bank. It's going to be the purchaser who writes it in. There are only two people who can, well, actually, three people who can, type of people who can deposit or cash a money order. The drawee, assume it says Mr. Landlord, the drawer, who's the purchaser, or whoever the drawee endorses the money order over to. So what do you get for non-payment of rent case? The landlord says, I never got the rent for October. The tenant comes in with the carbon copy, tenant's copy of the money order. Here's my money order, I paid it. It says, Mr. Landlord to drawee, and I have it. Landlord says, I never got it. The best evidence is going to be the business record of the bank or the company that sold the money order to prove, one, whether someone cashed the money order, and two, who that person is. So if you're anticipating this, try to subpoena in the bank records or the money order records. I typically, if there's that type of dispute, will continue the case to give the tenant the chance to trace the money order. But the copy is proof of nothing, except perhaps that the tenant did purchase a money order and nothing else. Gas, electric company records. Tenant can't prove, in the gas records, they have gas heat. Tenant shows that they're responsible for the heat, and they're paying $500 a month in gas bills. And they show me the gas bill. That in and of itself is insufficient to be proof that there's a defect in the boiler. It's just that she owes a lot of money in gas. You'd have to bring in someone from the gas company who would have to testify and explain usage and how it relates to that particular apartment, that particular heating system. The information conveyed, the information in the record is hearsay. And if the tenant just brings the tenant's copy of the bill, it's not the tenant's record, it's the gas company or electric company's record. And if you want to overcome any hearsay objections, you have to bring in the records, lay a business record foundation, or get a stipulation to bring it in for whatever you're going to be using it for. Canceled checks. In the old days, at the end of the month, I'd get back from the bank my original checks after they've gone through the transactional system. And people would come into court with the original checks to prove payment. Not bad. I mean, I got an original check, got an endorsement on the back, that's the landlord, so if it's rent, not bad. But sometimes the issue is going to be whether the tenant paid a security deposit or last month rent deposit. Big difference in terms of obligations. Tenant brings in the check, the original check they got back from the bank, and in the little notation, bottom left-hand side of the check, it says in bright blue ink, security deposit. The landlord says, I never accept security deposits, and that wasn't on the check when I endorsed it. But the tenant has the original check, should be able to put it in to lay the foundation. What should you do if you were the landlord and you were faced with that type of evidence? I guess you could just write another check for the treble damages that you'd have to pay if, based on the fact that you hadn't put a security deposit in a interest-bearing segregated account. Or you could do something else at the time of trial. Anybody have a suggestion? What type of records do banks keep? Anybody? Wow. Okay. Banks keep electronic records of every check. If anybody gone to the Bank of America machine and you actually put a check in, and do you want a photocopy back? Everything in the banking system now is electronically recorded. So what you can get if you subpoena from the bank records for that month for this tenant, you will see the check that actually went through the banking system at the time of the action. And you will see whether there was any words written on the check in the notation section. If it was blank, you know two things. You know that there was no security deposit and the tenant is a liar. Two independent pieces of information, if that's what you find. You need to think creatively about how to either prove or disprove aspects of a case. That's an example of it. Repair bills, everybody brings repair bills in. Landlords do it all the time. Here's my bill from the exterminator, and on the bill is, you owe me $500. It usually says paid, written by the landlord, and it says, the tenant is the worst housekeeper I've ever seen in my 50 years as an exterminator. To the extent that the bill is being offered to prove that the landlord contacted an exterminator and paid for the service, that is the landlord's record. To the extent that it is going to be offered to prove that the exterminator actually exterminated and the tenant is the worst housekeeper in the world, it is the exterminator's record, so you'd have to get the record in through the exterminator to prove service, and even if you did that, the independent statement opinion of the exterminator is hearsay and would be kept out. The exterminator would have to testify as to his observations or her observations, and subject to cross-examination by the tenant's attorney. So don't just roll over when a landlord's attorney comes in with repair records, invoices. Take a look at them and ask the judge to, if you make an objection, Judge, I'm willing to, I have no objection if this is just being offered for proof of payment, but if it's being offered for proof of the work or the quality of the work, I object for its hearsay. It'll be sustained. Or I will give a limiting instruction if it's to a jury, or I will make a notation in my notes to only for proof of payment. So that's, as a lawyer, that's how you can protect your client. If a tenant writes a letter to a landlord, we'll use that one. Tenant brings the letter into court. That's only the copy. So to overcome the best evidence rule, the tenant would technically have to ask the landlord to produce the original. And then if the landlord doesn't have it, then you could argue, put in the copy. But you'd have to lay a foundation for the fact that when the tenant prepared the letter, what the tenant did with it. Did they mail it? Did they give it to the landlord? When? You have to lay the foundation. Often what I get is the tenant coming into court with what looks like the original. And the tenant tells me, oh, I made duplicate originals. Now, if the tenant's working with a computer, possibly, because people just print, and then you got it. Less so if it's handwritten. That goes to credibility. So you've got to take a look at what it is your tenant's saying they prepared and think through, not just how do you get it in, but think through issues of credibility. Will this impact? How will the judge view this? What will the judge think about? That's strategy. Never, ever, ever bring anything live or dead into the court. And I get it all the time. Take a picture, or have your client take a picture. And then, so that it's dated, usually have the camera with the date or sometimes have a newspaper if you're totally paranoid. You want to make sure it's the same day, and then have your client testify as to what the tenant saw that day, and here's this a fair and accurate representation of what it purports to be, and put it in. But please, no cockroaches, no bed bugs, no mice. I think we talked about this briefly. Landlord complains of cause eviction. This is the worst tenant in the world, keeping other tenants up at night, loud parties, drinking all hours of the day and night, and that's what my tenants told me. All hearsay and should be kept out unless the landlord observed it or the neighbors actually come in to testify. So listen carefully for hearsay testimony, because often it gets mixed. Some of what the witness says is just observational, and then they just launch into what someone else said. You almost have to be instinctive. When the witness starts to say, and Johnny told me, on your feet, judge, the witness is about to launch into a hearsay answer. Now, I might say, how do we know that until we hear the answer? But I'll have my antennae sort of moving and listening for the hearsay. It's very important to get that before the judge, before the witness blurts it out, if you're before a jury. So just that's trial technique. That's where you get comfortable being in a courtroom and into the flow of a trial. Just listening to the cadence and listening to the rhythm of both the questions and the answers. And the question you should ask when it comes to hearsay, is this being offered for the truth of the assertion? If the answer is yes, can it come in for either a non-hearsay purpose, or is there an exception to the hearsay rule? If it is testimony of the tenant as to what the landlord said, it all comes in as an admission, and vice versa. If it's a argument about a fight between two tenants that the landlord's moving to evict because of that fight, and there's testimony that the other tenant who's not being evicted said something, and that something is a statement against that tenant's witness's interest, it may be able to come in as an exception to the hearsay rule. Again, you have to listen, and listen hard for what they're saying. Police reports. This will differ between whether you're in a court or if you're in an administrative hearing, but I'm just going to deal with the courtroom. Police reports can go in as business records of the police department. You can get the records certified. They can come in for the purpose of what the police officer normally does in the course of the police officer's work. That they responded to a call, that they observed, and everything that they observed can come in substantively. They talked to the tenant, and the tenant said. That can come in substantively. You're getting closer to the line, but because it would be an admission of the tenant. However, if the police report says, went to the apartment, spoke to the tenant, and upstairs neighbor told me, everything the upstairs neighbor said is second level hearsay and can be kept out because it's not the credibility and reliability of the police officers that is in question. It's not even whether the police officers accurately recorded what the neighbor said that's at issue. It is what the neighbor said which is being offered substantively. It's the truth of the neighbor's assertion. And that's what makes it hearsay. So when you get something like a police record, read it carefully, especially if it's a cause eviction, and figure out what arguments you can make to limit what information should go into evidence. And I would look at it and I'd make a determination. Then what we do is I'd mark for identification the unredacted police record, and then the document that actually goes into evidence would then be redacted. And the reason I'd put the unredacted one, mark it for identification, is to preserve the record and bring it so that if ever went up to the appeals court, they can see what it is I redacted, and they can make a judgment if it's necessary. Protect your record. Protect your record when you're trying a case. Make sure all of the documents that you want in evidence are placed in evidence. Before you rest, just check it to make sure that you've put everything in that you want to. When you are questioning a witness about a document, refer to the exhibit number. Mr. Witness, I am showing you the police report which is marked as Exhibit 2. That's the verbal path for both, mostly it's for the appeals court, to trace it if they're trying to follow the transcript. Pronouns, not very helpful. I'm showing you this. I know what they're talking about because I see it. I'm sitting in the courtroom. No one else looking at that transcript has a clue. So be aware that you are making a transcript. Also, in a court like mine, it's a court recorded by a digital recorder. Very sophisticated digital system with microphones all over the place. But not every place. It's your responsibility to make sure that you're heard on the record. So put yourself somewhere within a few feet of the microphone and just be aware of it. I don't care where you go in my courtroom to question a witness, but it's not terrific to be questioning the witness leaning over the jury box because you're going to be too far from a microphone. So take a look at the courtroom, see where the microphones are. There are microphones at your table, there are microphones at the podium, there are microphones at the sidebar, there's microphones at the where the witness desk is. The other thing is, if you're doing a jury trial, and we do have a fair number of jury trials in the court, if you're making an objection, do not make talking objections. You can say objection hearsay, objection leading, that's fine. But if there's going to be any further argument, it's going to be at sidebar outside of the hearing of the jury. If you're going to do something in a jury trial that you know is going to be controversial, don't spring it on me. Ask if you can come to sidebar and you tell me, Judge, this is what I'm going to be doing for this, and get my permission in advance, because I may set some ground rules that will allow you to do it, but within a certain procedure. I don't like to be surprised, and most judges don't like to be surprised. Private reports. You hire a private health inspector or a private lead inspector. And then you come into court with their 17-page, beautifully coiffed report. It's just perfect, far better than anything that the city or state inspectors prepare. It's not self-authenticating. It has to be authenticated, if it can be, as a business record of the inspector. So the inspector is going to have to authenticate it and then overcome any potential hearsay objections based upon, depending on what's in it. So don't just bring the report and assume it's going to go in. It won't. You have to bring the private inspector to testify. Rent ledgers, repair records, they're business records, and the proponent needs to lay a business record foundation from them. Go to any one of the dozens of books in the Commonwealth that talk about evidentiary foundations. Im Winklereid is one of the is a national one, but it's the one that I remember the first one I saw. It just lays the questions that you need to ask to lay a proper business record foundation or to authenticate a photograph. Write them out, and then just make sure that you ask each of the questions. If you get close, you're likely to get the document into evidence. And when I give you a hint as to what you're missing, listen to me, because if you do what I told you to do, it's unlikely I'm going to sustain the objection the second time. Calendars that your clients keep of all the horrible, terrible things that the landlord did or said to them, it's all hearsay. It can be used either to refresh recollection, or you can put it in potentially as past recollection recorded if the entries were made at or near the time that he made them or she made them. We talked about damages. Prove it. Get evidence of damages. And if you ever get a 13919 case, which is the public nuisance case, the way that they typically come into me is with a landlord seeking a temporary restraining order, civil action, to enjoin the tenant from remaining at the property. There's case law. I don't know if I cited it here, but that SJC case law that says that a tenant is entitled to a full trial on the merits before the tenancy can be avoided under 13919, which is a common law nuisance statute. I will issue an injunction if I believe that without the injunction, the landlord or the other tenants are likely to suffer irreparable harm. For example, if the tenant was running down the hallway with a handgun, shooting indiscriminately into the in the hall, I'm likely to issue an order barring that tenant from re-entering the property until the case was heard on the merits. But if the claim is that the tenant was the police executed a search warrant and found drugs in the apartment, and therefore I'm terminating the tenancy, it is unlikely that the court will issue a injunction beyond enjoining the tenant from engaging in illegal drug-related activity during the pendency and then until the trial. So if you're representing a tenant who's faced with the injunction, try to argue that there's no irreparable harm. In the interim, the presumption is that they can stay until the case is heard on the merits. And the landlord would have to prove one of the underlying criminal acts to recover possession. And it was New Bedford Housing Authority v. Olin that I was talking about, so you can read that case. And that, in a nutshell, is everything you need to do a spectacular job representing clients in the housing court.
A large nutshell, but a nutshell nonetheless.
Any questions? I know we're running 5 minutes late, but I'll take some questions, or I'll stay a few minutes if people just want to ask me something at the side. If not, I look forward to seeing all of you and expect to see all of you in my court in the coming year. And I want to tell you something, that I know most of you many of you work for large firms, and that you are doing sometimes small pieces on incredibly large, complicated cases and very interesting cases. I'm telling you right now that your experience that you're going to have in the court, the housing court, is going to be different and more rewarding than anything that you've experienced today. As large as the cases are that you work on, to your clients, their case is every bit as large as important as the cases that you are working on. You're going to be exposed to a segment of our society that you don't see every day. There are people who are living from paycheck to paycheck, from illness to illness, from unforeseen criminal act of a household member to another one that they can't anticipate. And all it takes is one piece to fall, and the rest of their lives start cascading out of control. You are going to be in a position to actually have a substantial and life-affirming impact on those people just by leveling the playing field in an environment that is completely alien to them is going to be something that is going to be uniquely valuable and something that you are going to remember. And when you leave and you go back into your work world, you won't forget it, and you're going to bring skills and, I suspect, a sense of empathy that will be with you forever. It's going to be a world that you've never seen, and I think that everybody ought to. And I want to applaud you for taking the time and willing to make the commitment to do this. It's valuable to you, but it's going to be more valuable to your clients. So thank you, and I look forward to seeing you. And none of you are going to faint the first time you stand up in my courtroom.
VLP has a presence at the court on Wednesday mornings from usually around 8:45 until noon on that day, and then on Thursday from hopefully folks can get there by 8:30, 8:45 until sometime in the afternoon. And we appreciate what time you can give us. Our hope is that as you come to housing court, observe the court, because that's what we recommend you do at the beginning, and then start working your way. You start by advising people, and then you might want to go into negotiations or mediation. Our hope is that eventually you will be going into court either on a limited assistance representation or taking a case for full rep, which is where you can do the most good. So I have your contact information. You will never escape. Contact us. Go on the VLP website, www.vlpnet.org, and you can sign up on Volunteer Hub, or you can just contact either Hugo Nakai or me to let us know you're coming, or you can just show up on a Wednesday or a Thursday, and we'd be most grateful to have you.
Joanna's
Thanks.
not kidding. She'll probably be at your doorstep on Halloween.
No treat, just the trick. Thank you again for coming and for your time. So we'll hang out here for a minute. I feel like that on Thursdays. I know you mess. At the end of the day, I think I've used 1,000,000 words today. 1,000,000 words.
Yeah, but sometimes I feel I've used the same
Words 1,000,000 times. Yeah, there's that too.
It's fine. It happens all the time. So have you gone to the housing court for a day yet? No. This yeah.
Sure, of course.
Nice. Oh, sure. Sorry.
Mm-hmm.
You don't know what goes on in my courtroom. I have babies crying. I have cell phones going off. I have people starting to scream at me. It's I have a pretty high tolerance. But we do also announce that to turn them off at the beginning of the court sessions.
In the meantime, let me ask
that's
you,
what everybody
where's your
thinks.
fellowship?
That's all right.
Lynn, well, they have a housing court in Lynn.
They do as a juvenile.
Yeah, and so to the extent that you can take some time between now and the time you have more time to go in and observe, keep it kind of fresh in your mind.
No,
Also,
I can't,
keep an eye on
bring
VLP's
work
website,
forward.
we offer housing
I should
meetings
have,
there as well.
It has to be where the tenant is not at fault.
But to the extent that you can go in for,
Or other good cause on the part of, yeah, but if it's not payment of rent, or the claim
Well,
is
they
the
would probably
tenant chronically
want you to
late
go in
payment
and
rent, or the
observe
tenant
some
was causing
cases.
damage. No, the only, you can bring 8A, you can bring 2A affirmative defense, but you can't bring counterclaims. Now, some judges take the position that while the tenant has no right to counterclaim, it's discretionary with the judge as to whether to allow or not in a cause-based case. Some of my colleagues and I disagree as to that. I think the answer to that is no.
You learn a lot from
Some
watching what's going on.
different.
And there's
Yes,
also
they do it
good
differently,
attorneys who are up in that.
presumptively, you're not going to be able to
Mary
bring a
McValley
counterclaim.
comes over there, and
Your best focus is to defend against the
you can
cause.
see that
Yeah, exactly.
the practice and what people are up to. And I don't know if they have an attorney for the day project there, but I think they have a presence in that court up there. I know I worked with them on that at some point, getting it started up there. So, and if you're ever in Boston on a Wednesday or Thursday, we'd love to have you.
It's not that many new people each time, because a lot of them are the same landlords you get coming in.
I'm certainly happy to come in and help.
We don't take them because we represent the
Nervous.
Yeah, but you know what?
and they're all, we're not gonna be able to accomplish. People who.
Okay. So.
No, I understand, but I guess you might be representing them. Like he's adverse to a landlord that you might represent.
So that's, yeah, so
we do the conflict checks on the landlords to make sure we're not adverse to the landlord. and not the
Okay,
tenants.
let's be careful.
But
This
then we
is still
figure
being
if
recorded.
the landlord is a person, we're not gonna have a conflict
Thank you.
with it.
Yeah, but I assume, by the way, that if you're representing the landlord, you do the conflict check against the tenant.
Exactly, but we don't, and so we also do that, we only do the tenant side, we don't do
Yeah.
the
Okay, so your
landlord.
firm has a policy, when you go in there
Yep.
for VLP, you stick to the
We
tenants.
stick to the tenants. Yep, so then we only do conflict checks for the
Their
landlord.
firm, but VLP.
No,
Oh,
right,
yeah,
their-
yeah,
their
VLP,
firm-
Yeah,
their
that's
firm's
fair.
policy,
Policy, yeah,
when you go in,
because VLP
Yeah.
represents both.
Yeah, understood.
Exactly, yeah, so we only do tenants, we do the conflict checks on the landlords, and then we just keep the spreadsheet, and then there's some where like, oh, we didn't have a chance to meet this week, so then we just have our list, and then we're like, oh, we can't do that one. There's a lot of people coming up, so half the time they're literally fine, most of the time, you know, you can find a landlord with just a person's name. You know what I mean? And so, but it is a pain. And so, but once you do it a few times, then it is just like you get fewer
How'd you do?
hits. Exactly,
Hi. I'm glad that
exactly.
were you a
Exactly.
student back then? At Harvard? Or BU?
Yes.
Oh,
Yep,
okay.
yep.
And so where are you working now?
There you go, yeah.
have her on my side.
Exactly, and if she wants, and we have like,
Oh, wow.
you know, our person didn't like the
Okay, that's
disclosure, we
great.
have our own
So
acknowledgement.
I think
forms
that
actually say next
this is a
level,
great thing
that
to
we
do,
have them sign. So
and
there's
it'll give you a
VLP
good experience,
acknowledgement
if
forms.
nothing
And
else.
so,
And
you
maybe
know,
you'll have better luck the next one.
Yeah, so we have
But
our own
frankly,
special,
I'm sure
so,
your
you know,
client
I'd
did
have it
better
for, you know, if
having you.
yeah.
And
Um,
who was your supervisor?
I'd be
back then?
happy to, you know, talk to people and let them, you
Okay.
know, and so that was kind of
Oh,
our
I
system.
remember
We came
this.
in. And truthfully, there's a lot of the firms don't do conflict checks.
And,
Go in.
but I'm
And,
glad to
you
have
know,
you back.
if they actually,
And, oh,
and
my
so like,
pleasure.
we're unusual in that we even, I think if they took the case into full, you know, they would do the conflict check, just to, because you're literally, a lot of times I'm just answering questions for 20 minutes with this person, and so. Yeah, no, I think I'm kind of like, dear Jesus, like we, you know, but we have our people. Wait, before you go, I'm gonna, no problem, here, let me give you my card, and you can, although I don't know if they have my contact information.
I'm gonna run. Nice seeing you
Nice
again.
to see you also, and hopefully we'll see you at our next, I don't know when our next,
December.
December?
No, October, November.
Yeah, I didn't make
One of
that
these
one.
upcoming months.
October, November, or December?
No, I didn't make it because I don't know, I had a good reason.
Awesome.
Are you practicing real estate?
Environmental. So I do, yeah.
Litigation or corporate?
We do everything. So real estate, litigation, corporate. Yeah, regulatory. So, yeah. Yeah, so we do some, yeah, CERCLA.
I don't know, that doesn't sound.
So, yeah. So I do environmental, and I have literally no, and the only reason is because like I like do our program, and then I like put together a binder, so she's like, I need someone in the real estate community. I'm like, okay, I'm like, well, I expected to do as like something environmental, but this is, oh, it's great.
It's close to.
Yeah, real estate, yeah.
But of course, you can get it to environmental.
Exactly. So, no, so definitely shoot me an email and I'd be happy to talk with them, and then we can come and do a training. You know, come to your firm and do a training, on, you know, if other people want to do.
It's actually,
Yeah,
we only got like 4 associates, so
Yeah.
it's actually like a
Yeah.
small.
Yeah.
I'm not sure how many people.
Yeah, but that's always and then if you look on VLP, and like we put together a binder that has like goes
Yeah,
into
something
super
does.
detail.
I have problems with that.
And it's actually on the VLP website, and then we're actually updating it, so I could get you that.
I can check the website too, so
Yeah.
I don't wanna.
No, but we're actually,
burden you
we're
with anything.
updating it.
But then, too, I think I can come in
Was this
and
parents'
watch for a few times.
And that's the best thing, and like literally, like I was saying,
Oh,
for this second, I hardly make it to the meetings, it's like.
Yeah, actually, I'm lucky, we get some small matters that I've been able to
Then we
go
could
in
react
court
to it.
or district court
Yeah.
for, so, and everything's right, like you go in there, you can just make a bunch of,
Yeah.
and you do it by yourself.
Yeah.
You remember it more than any
Yeah.
memo that you ever wrote
Yeah,
for the most
exactly.
senior part.
Yeah, exactly. So yeah, feel free to email me and I'll definitely,
Thanks, Kate, it was nice to meet you.
nice to meet you also. I'm giving you this and so you can look over it. This is my email. I just want you to
Okay.
look over to the real estate, the steering committee,
Uh-huh,
that we're gonna
okay.
send them to make them give us money. And then, and then this is the 3 points in the letter about, I just wanna make sure they're up to date, like you
Okay.
take so many cases,
Okay.
and it's in the email that I just wanna double check and
All
send
right,
it
and I
out.
will get back to you on that tomorrow.
Perfect!
God willing, and the creek don't rise. That's my willing.
Is it raining? It was nice today.
It's been, oh, I know, so nice and warm.
It was
I love that.
75 out there.
I know, it's gorgeous. But it felt a little tornado-ish to me. You know how sometimes there's a certain pressure in the air?
Well, there was supposed to thunderstorm, I think, tonight.
Maybe that's what I was feeling.
But I-
was gonna come in this afternoon.
I've got the umbrella.
Well, that's why I said I
and
brought my
rain
umbrella
gear.
and my coat, and of course it doesn't.
And I have carried it all around.
Because my iPhone said it's gonna be raining by 3 o'clock today.
That's what, yeah, I looked up my weather.
Yeah,
thing,
that's
and-
not that accurate these days.
Last-
Then I have another one, I have a ripple radar thing on my iPhone, I looked at it, and the full range of rain was coming, was at, Hartford,
Oh.
and started heading west, so that Hartford is usually 3 or 4 hours.
What time was that?
Well, before I came here, so it should be.
Oh, it's
it
15
should be
minutes.
raining
Oh,
out
come
there.
on, let's go.
Yeah.
Parking lot.
I am,
All right.
but I actually not actually this.
Oh, I read that. My
That's
So my
that,
guys are-
there, you can see it now.
This is the one in San John, was it?
Oh, it's actually there.
Oh, that's right, we
It's
got somebody else to send
So
it.
is that?
Oh, we got some time.
Yeah, you got still another 2, 3 hours for it.
On the 6th,